Hello, good morning students. Please subscribe the channel, drop a like, share and comment. This is Shree Vishnu Art Press Publications exercise number 3 and 4 on the speed of 90 words per minute. Start. We shall now examine the decision in Roop Singh Supra on which practically the whole of the arguments on behalf of the claimants were rested. On examining the facts, it is found that was a case which related to a claim by a third party. In claims by a third party, there cannot be much doubt that once the liability of the owner is found, the insurance company is liable to indemnify the owner to any defense that may be available to it under section 1492 of the Act. In case where the liability is satisfied by the insurance company in the first instance, it may have recourse to the owner in respect of a claim available in that behalf. It may have recourse to the owner in respect of a claim available in that behalf. Roop Singh Supra was a case where the insurance company raised a defense that the owner has permitted the vehicle to be driven by a driver who really had no license and the driving license produced by him was a fake one. Their lordships discussed the position and held ultimately that a defense under section 1492 of the Act was available to an insurer when a claim is filed either under section 163A or under section 166 of the Act. The breach of a policy condition has to be proved to have been committed by the insured for avoiding liability by the insurer. Mere absence of production of fake or invalid driving license or disqualification of the driver for driving at the relevant time are not in themselves defenses available to the insurer against either the insured or the third party. The insurance company, to avoid liability, must not only establish the available defense raised in the proceeding concerned, but must also establish breach on the part of the owner of the vehicle, for which the burden of proof would rest with the insurance company. It becomes very clear from a perusal of the above mentioned case law of this court that the insurance company, in order to avoid liability, must not only establish the defense claimed in the proceeding concerned, but also establish breach on the part of the owner or insured of the vehicle, for which the burden of proof would rest with the insurance company. In the instant case, the respondent company has not produced any evidence on record to prove that the accident occurred on account of the overloading of passengers in the goods carrying vehicle. Further, as has been held in the case of B.N. Swaroop Supra, that for the insurer to avoid his liability, the breach of the policy must be so fundamental in nature that it brings the contract to an end. In the instant case, it is undisputed that the accident was in fact caused on account of the rash and negligent driving of the offending vehicle by its driver, against whom a criminal case wide FIR number 66 of 210 was registered for the offences referred to supra under the provisions of the IPC. While applying the principle of horizontal reservation, category has a role to play, as at the point of time when horizontal reservation is to be pressed, then based on merit, candidates in question are to be adjusted in their respective category, and the male candidates who are at the bottom of the list as per the merit will have to make place for women candidates. A candidate who has proceeded to make an application for the purposes of horizontal reservation under the OBC, SC, ST category cannot be permitted to change his or her category, whereas in vertical reservation, once you are selected, such a change is permissible by operation of law, and in view of this, once such is the factual situation that is so emerging that all the candidates, once they have specified their category in reference of special reservation, then they have to be adjusted in their respective categories, and the reserve category candidate cannot ask for placement against open category by claiming that they have higher merit, inasmuch as only in the matter of vertical reservation merit has a role to play wherein the list is finalized, but at the point of time when for providing horizontal reservation adjustment is to be made, then various adjustments is required to be done as per the formula that has been approved and ratified by the apex court, that in the matter of horizontal reservation, adjustment would be made by making appropriate placement in appropriate categories. The apex court was conscious of this fact that such a provision may be subjected to misuse, and accordingly position was sought to be clarified by giving examples and then providing that if horizontal reservation is not satisfied, the requisite number of special reservation candidate has to be taken and accommodated or adjusted against their respective social reservation categories. Subsection 3 of Section 3 of UP Act number 4 of 1993 provides for horizontal reservation to be applied accordingly. The application of horizontal reservation in this prescribed manner maintains the merit of special reservation quota candidate along with their representation in service. In view of this, The learned single judge is absolutely right at the point of time when he has proceeded to criticize the state government for taking such a stand and for adhering to a procedure that was not at all prescribed in law and thus crossing the limit of reservation of 50%. In view of this, the order passed by learned single judge does not deserve interference on this aspect of the matter. We have already noted the judgment of the apex court in the case of Ashok Kumar Supra, wherein the concept of horizontal reservation as to whether it is a case of overall reservation or it is a case of horizontal reservation has been discussed and elaborated in detail. The way and manner in which horizontal reservation is to be implemented and given effect to has also been dealt with in detail so that it does not proceed to cross 50% limit that has been provided for the reserved candidates in question.